Hello, Your Honour. My name is Orford, O-R-F-O-R-D, initial T, and I appear for the plaintiffs, Simon and Diane Lee. Today I would like to address two issues, Your Honour. The first is that my client is seeking to rescind the lease with PFO for statutory misleading or deceptive conduct regarding statements as to future matters. The second is Premium Factory Outlets, or PFO's counterclaim to stop my client from denying entry into the lease of T34. In regards to misleading or deceptive conduct, Section 18 of the Australian Consumer Law states a person must not, in trade or commerce, engage in conduct that is misleading or deceptive or that is likely to mislead or deceive. PFO constitutes a person as defined in Section 131 of the Competition and Consumer Act 2010 Commonwealth, and as PFO's primary business is the letting of commercial premises, its conduct has clearly been in trade or commerce, as defined in Section 2 of the ACL. We are seeking an order for rescission of contract as stipulated in Section 243A of the CCA 2010, based on Section 4 of the ACL, that PFO made representations about future matters that they knew were false, specifically in regards to the financial capacity and exclusively premium nature of the PFO shopping centre. It was conveyed that the centre would function exclusively for upmarket clients supplying premium products as evidenced by the name of the company, architectural design, brochures, research quoted and oral advice of the Selmors, agents of PFO acting on behalf of the company as defined in Section 139B of the CCA. Further, they are liable for the information that as they were not merely passing it on, as explained in Butcher and Lachlan Elder Realty, Pty Ltd, 2004, 218, the Commonwealth Law Reports at point 38. At no juncture was my client informed that these representations were subject to complex and varied economic factors, which could lead to a change in the nature of the centre. It was the representation of the centre's exclusive use as a premium shopping destination which led my clients into error. The fact that there was dissent from one of the PFO directors attests to the fact that PFO did not consider its exclusive premium usage to be guaranteed, but rather that they were dependent on economic factors. Despite this fact, they failed to ensure their marketing material used by the Selmors was properly disclaimed. As the statements were made to individuals, the court must ascertain if the conduct was likely to mislead a reasonable person in the position of the representee, as espoused in Downey and Carlson Hotels Asia Pacific Pty Ltd 2005, Queensland Court of Appeal 199 at point 69. As proprietors of a small family-owned business, they had experience but were not sophisticated parties, and would not have entered into a contract for a business that could change in discourse entirely. They did not have the financial capacity nor the emotional fortitude due to personal circumstances to do so. Further, it could be reasonably understood by such applicants that the clause in the contract regarding the centre's ability to change the tenant mix and logo would not include a major departure from the nature of the centre, that is, a luxe upmarket destination. In Carpet Holdings Pty Ltd and Former Holdings Pty Ltd 2004 in the New South Wales Court of Appeal 150, a claim of misleading or deceptive conduct was founded on the representation found in point 6, that the centre was to be used exclusively for the sale of bulky goods and retail sales of products used in the home building and renovation industry, which misled them into signing the contract. While this case was dismissed, there was significant emphasis placed on the experience of the director and negotiator of the lease, Mr. John, of Carpet Holdings, as proof he did not rely on the misrepresentation when entering the contract. He had over 2 decades of experience, 9 stores, $10 million gross profit, and had reviewed and amended numerous drafts for the lease in question. It was therefore found that he was not likely to have been misled by their representations. Clearly, his experience is not analogous to my client's. Further, the case is dissimilar in that the exclusivity of bulky goods and retail homewares was found to be untrue, as the centre had always planned to have a food and beverage aspect to it. PFO, however, had no such mitigating factor. In addition, it was suggested in paragraph 30 that Carpet Holdings had the capacity to alter the product mix, and that the store could continue to act as a referral point for other stores given. My clients, however, have no such capacity to alter their product mix and have no additional stores with which to create synergy. They would likely have to liquidate their current holdings and procure new suppliers and new products. PFO also engaged in misleading conduct as they did not have the financial capacity to undertake their planned proposal for the centre, as evidenced by creditors descending upon them within 3 months of it opening. In Awards and Twin Creek Properties Pty Ltd 2012, New South Wales Court of Appeal 200, at point 35, it was accepted that not only must future representations be based on actual intent, but the company must also have the requisite ability to undertake them. In summary, PFO misrepresented their financial capacity and its exclusive use, which led my clients into error. They should therefore be compensated by rescission of their contract. In regards to the defendant's counterclaim of estoppel, it is my contention that their claim cannot be successful as it has no real basis in law. They had no realistic expectation to rely on my client's statement that they would open a new shop in 6 months from the establishment of their initial business, as the representation has to be clear, as stated in Legioni and Hately, 1983, 152 Commonwealth Law Reports 406, at points 406 and 436. But it cannot be so if important information is omitted, as held in Mobile Oil Australia Limited and Lyndall Nominees Pty Ltd, 1998, 153, Australian Law Reports 198. The terms and conditions of the lease, however, were not discussed at all, rendering the representation toothless. In Crown Melbourne Limited and Cosmopolitan Hotel Pty Limited, 2016, of the High Court of Australia, 26, at 198, it was determined that the tenants in question could not have reasonably expected a renewal of the lease for 5 years on the same terms and conditions as had been already agreed on, or terms approximating them for the same tenancy. Similarly, PFO cannot reasonably expect that my clients would take on an additional lease in the future for T34 with the same terms and conditions agreed to for an entirely different tenancy, that of T33. In Sidhu and Van Dyke, 2014, 251 Commonwealth Law Reports, at 505 at point 71, reliance must be proved by the defendant as a matter of fact. The plaintiff therefore must show that they were not going to entertain my client's submission for T33 without T34 by way of adducing evidence that more experienced applicants for homewares had applied. Brennan J's narrow description of the circumstances where estoppel can be utilised in Walton Stores Interstate Limited and Mayer, 1988, 164 of the Commonwealth Law Reports 387, is routinely cited. He states that there must exist a situation where a party believes a legal relationship exists between them and the other party, and that the other party would not be free to withdraw from the relationship. In this case, PFO intended to have their solicitors prepare formal documentation of the agreement, demonstrating that each party was free to withdraw from any representations made during what ostensibly could have been the first round of negotiations. In Capital Market Brokers, Pty Ltd and Hamlin, UPC Limited, unreported from the New South Wales Supreme Court, 2nd of May 1989, it was this intention to prepare formal documentation that prevented the court issuing the benefit of estoppel. Unconscionable conduct is the cornerstone of the operation of equitable estoppel, as demonstrated in point 27 of the Waltons and Mayer case, and as such is meant to prevent victimization, not protect against foolishness. To assert that my clients engaged in such conduct with a large corporation, much better equipped to engage in sharp business dealings than they are, is farcical. PFO had the opportunity to formalise their negotiations when they sent the lease for T33 and failed to do so. In Austertel Pty Limited and Franklin Self-Serve Pty Limited, 1989, 16 of the New South Wales Law Reports 582, Justice Kirby said that well-advised commercial parties should be treated with greater scrutiny than those in other relationships. To this effect, it was held that the court would not interfere with the commercial decisions of Franklin's to withhold consent to the lease by granting estoppel. As a well-resourced corporation with superior bargaining power, technical expertise, and access to professional advice, it seems similarly unsuitable that the court grant PFO's claim of estoppel. Finally, the object of estoppel is not to enforce promises, but rather to avoid detriment, as stated in the Mobile Oil Australia case. While enforcement of the promise can be what is required to avoid detriment, I assert that if Your Honour is to find in the defendant's favour, that compensation be based on the defendant's reliance loss be ordered and not their expectation loss, as in Commonwealth of Australia and Verwine, 1990, 170, Commonwealth Law Reports 394. In summary, estoppel should not be granted as my client's representations were not sufficiently clear, were subject to contract, and do not constitute unconscionable conduct. Thank you for your time, Your Honour.